Ethically Speaking is a podcast of the Institute for Enterprise Ethics at the Daniels College of Business.
Welcome to episode 20 of Ethically Speaking, a podcast hosted by the Institute for Enterprise Ethics at the Daniels College of Business at the University of Denver. This is Dan Sweeney, and I'm the director of the Institute for Enterprise Ethics. The topic for today's podcast is the eavesdropping employer, and we want to talk about how employers monitor and oversee the activities of their employees while at work. It's based on a paper written by one of our professors here at Daniels, Corey Ciocchetti, and it was published in the American Business Law Journal. Corey is an associate professor of business ethics and legal studies in the Daniels College of Business. He clerked for the Honorable John Kane in U.S. District Court in Colorado and founded and ran a small business providing sports programs to cities and parks and recreation districts before joining DU. Corey's right here with me, and we'll get into the conversation right now.
I do a lot of research and speaking on employee privacy and employer monitoring, what I call the eavesdropping employer phenomenon. And what got me into this is I did a lot of my own websites. I have my own business where I do a lot of public speaking, and I didn't want to pay a lawyer to write my privacy policy. And as I was getting into this privacy policy stuff for my website, I was just reading about how as long as you don't say anything, you can pretty much do anything with your, people who are on your website's data. And so I started thinking about how does this apply to the employment context, and what I found out is employers can basically monitor everything about their employees as long as they either don't say anything or put this huge legal document in front of them and make them sign it. So I got into this, trying to figure out what are my rights as an employee and how can I sort of teach my students how to be careful in the workplace. And what I've found a lot is it's just not very transparent, and so a lot of my work is on how to make it more transparent.
Thanks for that background, Corey. That was helpful. Tell me this, how significant an issue is this question of employer eavesdropping? Is it like ubiquitous, it's everywhere, or is it a fairly rare occurrence?
It's hard to measure that because employers aren't really forthcoming with that data. But what I've read is, up to 50 to 60% of employers will monitor people. And then of the 60%, 50% of those have actually fired somebody because of something they found. So, I would say that's pretty ubiquitous in the workplace. And, maybe eavesdropping isn't the right word. But again, maybe it is if they're not transparent about what they're doing.
Well, that sounds like fairly high percentages to me, Corey. Why do employers want to eavesdrop on their employees? What do they hope to achieve?
And if you just read this in the newspaper or watch CNN, it's going to seem like it isn't fair and they shouldn't be monitoring these people. But think about the reasons why they might. So there's a ton of legal liability involved when your employees are doing the wrong things. So think about someone sexually harassing someone via email or online or something, or think about disclosing confidential information to a competitor over email. Think about pornography or gambling, these types of things. If you're an employer, you have to know that's happening because you're responsible, right, when you get sued. And then you're also paying these people to work. So, you want them to be productive. You're providing the equipment. It's your equipment, and you don't want it to be misused. And so, the reasons they do, in that sense, are good, and I think they're ethical, and I think they're legal. Where it crosses the line is how much of it are you going to monitor? Are you going to follow them into the bathroom? Well, it's interesting because that's where most people steal. So let's say you work at Target or something. They've done studies that show employees steal and customers steal in the bathroom. They'll take the item into the bathroom and steal it. So should you be able to put a video camera there? And courts have said yes, as long as it's not in a stall. So, it sounds terrible, but then you see, well, that's where most theft happens. And so where's that balance?
Corey, I would think that a major motivation for a company to surveil its employees is to protect the company's confidential information, trade secrets especially.
Right, and think about that. If you're running a business and you have a trade secret and it gets exposed, you lose protection, right? You'll lose legal protection for that. So that's a wonderful reason. And think about defamation. People defaming, slandering each other, libeling each other over email. It's bad. Or sexual harassment, any of that stuff. You're responsible as an employer for not knowing about it, and that's when you really get in trouble. And so you're supposed to know about it and take corrective action. Well, these sexual harassers, they're not doing it in public. They're writing private emails and private texts, and how else will you know?
So the employers do have a good reason, and that makes good sense. On the other side of that question, what are some of the potential negative consequences or effects of monitoring employees, both to the employees and to their employers?
Right, and I don't want this to sound one-sided, Dan, like the employers are totally in the right here. I mean, there's a ton of negative consequences, and number one is you're going to have a major invasion of privacy, potential with all these things, and what does that do in the long run? You have a right to that, and it's morale killing. So if your employees think they're being monitored at all times, where they are, their security badges are monitored, are they in the office, their email, their text, they're going to be less productive, right? So there's this balance of you can legally do this, ethically should you? And from a business perspective, should you? And a lot of times the answer I come up with is not as much. There's a ton of negative consequences, a ton of positive consequences, which is why I advocate for a balanced approach. If you listen, I will say this: if you look this up on Google, you'll find people anti-monitoring and pro-monitoring. No one's in the middle.
Yeah.
But the answer in life is usually in the middle. So that's where I am.
Yeah. So these executives have to earn their salary and make a decision.
I think that's right, and balance it out, right? Balance it out.
So, Corey, when I read your paper, and I did read the whole thing, by the way.
Except the footnotes you said.
It sounded like there wasn't a lot of regulation on this issue. Are there any kind of really important and significant federal, state, or local laws or regulations that guide and sort of constrict this process?
If you're an employer, you're hoping Congress deals with this so that you don't have 50 separate state regulations to deal with. But, Congress can barely pass a budget. These laws get proposed all the time in Congress and nothing happens, and they're called awesome things like the Employee Privacy Protection Act. Like you'd think that would have the votes, but, Congress struggles. So at the federal level, there's very little. There's wiretapping laws. And what you do is you take these laws that are meant for a different realm, like criminal law, and then you apply it to, business eavesdropping, and it doesn't work that well, right? So that's a problem. So then states have gotten frustrated, rightfully so, and passed their own laws. So California is very privacy protective, and other states have, zero real privacy laws. And so it's a smorgasbord of experimentation on what works. And so if you're an employer that's frustrating, let's say you do business in 50 states, you have to really be diligent to keep up. And so what ends up happening, and I don't know that this is right, California becomes the de facto Congress for the nation. So you take the strictest privacy law, and then employers just comply with that. And so California is setting public policy for Alabama, et cetera. And so I don't know that that's right either. But I don't have much of a problem with states experimenting here. At the same time, I wish Congress would do a little more.
That's the same role that California played in the automobile emissions standards as well.
Sure.
Are there any standards that are set by industry, like industry trade associations? Can they do something that's more uniform across all 50 states?
They have. It reminds me of video game ratings, right? So this video game is, R-rated or whatever, and, that doesn't matter to anybody because it has no teeth. So they try. The National Labor Relations Board has some power here, but it's a real mess. And, I wrote this paper in 2011 or whatever, and today it's the same mess.
Yeah.
Now, Europe, we should talk about this. Europe is very privacy protective, and the EU is a totally different world, and that thing is overly regulated. So if you're an employer over there, you have lists and lists of bullet-pointed policies you have to comply with. And again, I think the answer is somewhere between America today and the EU today.
You do a great job in your paper of identifying and describing a number of employee monitoring techniques, what the technologies are and processes are, how they're used by companies and for what purposes they're used. You then categorize them into 4 very helpful groups: best practices, risky practices, borderline practices, and poor practices. I'd like for you to talk a bit about the techniques that you categorize as best practices. First, what are they? What monitoring techniques are included in this best practices category?
Right, and it's interesting, it hasn't changed much even though we're 7 years later, right? It's the same sort of thing. You do need to monitor what your employees are writing in their email. The way to do that is to, keyword search it for words that would red flag it. Instead of just reading every single email, you could, keyword search that. I think that's a good practice. And, you should know where your employees are. So if they have to have a badge to scan into the building, I think that that's a good practice. Again, if you get sued, if something happens, you want to know who was where. And that kind of stuff doesn't make people chafe. They're just accustomed to scanning their badge at the door. Where it starts to get questionable, in my opinion, is the video surveillance, the GPS tracking devices on cars. And again, I get why you might want to do that. So if you disclose that, I guess I'm okay with that. Where it gets really sketchy is this keystroke monitoring, where you're seeing how fast your people type, or how many times they hit backspace or delete, because that means they're not productive. I mean, they've never seen me type. I mean, I'm a terrible typist. That doesn't mean I'm bad at my job. But there's wiggle monitors they put on chairs to see how much you wiggle, because the more you wiggle, the less productive you are. I mean, are you kidding me? I would put those as poor practices. Phone call, there's some laws on how much you can listen to in a phone call, but even doing that at all is really disruptive to your people. So the best practices really are just kind of knowing where your people are in the building, looking at what they're emailing on the equipment you provide them with, like a keyword targeted sort of approach, and then the rest of it is based on what your industry is and how well you disclose it.
Why are these particular techniques that you talk about as being best practices, why are they called best practices? I mean, what criteria do they satisfy? And I think there were a couple in your paper. I can't remember them, but I did read it.
Is it a footnote? That's why if you were to look at the greatest good for the greatest number of people sort of approach to this thing, the best practices we're talking about here are the stuff that is in the greatest good for the greatest number. So, if trade secrets leak out via an email, everybody in the company is hurt, right? So I would call that a best practice if you just kind of weigh the pain versus the pleasure of that. And, same thing with knowing where your people are in the building, when they leave, when they arrive. I think, it's in the greatest good of the greatest number for people to sort of be monitored in that way. But you look at the wiggle monitor, or the typing monitor, or the video camera in the bathroom, or the video camera in the cubicle bay, and you're wondering, is that causing more pain than it's causing pleasure? Is that even helping productivity?
Is there a criterion that you might use to judge these having anything to do with the purpose of the monitoring, or the applications that...
Look at it from a legal perspective. Take the ethics away from it. Where do you get the most bang for your legal buck? Where are you most liable? And it's in this stuff that happens over email, right? It's the sexually harassing emails. It's the confidential information emails. It's the, just general harassment, bullying emails. That's the kind of thing where you're most legally liable, right? So if you were to take all the different torts, let's call them, or civil actions that could come, from email, it's more. And so that's why you'd want to monitor that more. So I think ethically and legally, that's why I call them best practices, because it hits both.
Now let's go to the other extreme and talk about monitoring techniques that you put into the category of poor practices. That's the lowest end of the scale. What are some of the specific monitoring techniques that you classified this way?
So, the wiggle monitor we tease, but it does exist, but it's not that. It is that. It's obviously poor. But, more likely it's things like following people home from work to see what they're doing. And you would see why an employer might want to do that. If someone has a cocaine problem, and they might come to the office high, you could get in trouble for that as an employer. But, starting to follow your people home and what they do on their off hours, I would consider poor. And a lot of jurisdictions have sort of enacted laws to prevent you from doing that. Or in Colorado, right? What if someone goes home and smokes marijuana? It's perfectly legal, and the employer finds out and doesn't want that. That again, that type of monitoring for me is poor. You could also really, you could make people take their ID badges home with them, and know where they are after hours. I could see a law firm doing this. Well, we need to know where you are at 8 o'clock so you can be available to us and that's poor. Just because the ID is in the badge doesn't mean that, they own you for after hours. So that kind of stuff is more ubiquitous than you think. Because this is a case of employers not being governed by laws in any way, not putting a ton of thought into this and taking it too far.
So is the sort of the criterion for classification of these techniques is one of the criteria the degree to which they invade the employee's expected privacy?
We should talk about that. People say you have this right to privacy, and it's more of an ethical thing. In America, you have no constitutional right to privacy. It's not even in the document. Where you sort of get in trouble is defamation type things, where someone slanders your reputation and it costs you money. There's someone, steals something from your purse or watches you take a shower. These are the kind of things, but it has to be really, really, really bad to be an invasion of privacy under the law. So when people say I have this, right to privacy as an employee, that isn't true. So, what I tell people to do in that case is just be careful and understand what you're doing. So if you're going to text from work, use your regular phone, one they didn't provide you.
So I got to ask you this one. Every once in a while in the press, there's some story about a company investigating somebody in their employee, and they do some dumpster diving. Where do you put that? Where do you classify that one?
For what purpose would you say that? What were they looking for?
I can't remember, but some kind of a document, some kind of a piece of paper.
Yeah, so let's call that poor. But let's talk about decent. Let me call this dumpster diving. It's not what you would think. But let's say that you have a social media profile that's public. And I go on there, I'm going to hire you. And I go on there and see that you are having, doing cocaine on your Facebook post. To me, a good practice. That's a best practice. You should look at what your, people's social media profiles are. And what you can't do by law in a lot of places is force them to give you, their password so you can log in. But if it's sitting there public on the internet, I can see it and should. But, diving deeper than that, trying to find, dirt on somebody, I would call that poor.
Are there any circumstances or purposes that give a company kind of permission under which you would suggest that these techniques actually be used?
A poor technique?
Yeah.
Yeah. So let's say it's a really, really sensitive industry and you have a ton of sensitive data. The secret recipe to Coke or whatever, and it's available to a lot of people.
That's Coca-Cola you're talking about.
Coca-Cola, yeah. Your trade secret, right? It's not that, it's something else. And so depending on that, you're a defense contractor, and there's this technology out there, right? So yes, but generally these are poor. But industry specific, maybe not. Let's say you are a retailer and you have, your losses are in the millions of dollars a quarter from theft. Maybe you do think about putting a video camera in the bathroom by the sink. Right? Mm-hmm. Or you're just going to continue to lose that money. Maybe it's not poor in that industry, whereas it would be poor here at DU, obviously.
Sure. Okay. Corey, is there a distinction to be made as to whether it's more or less appropriate for an employer to monitor an employee's activities if they're using their own property, such as their cell phone, their own tablet, their own car, their own uniform, and whether they're using the company's computer or cell phone and so on? Is there a distinction to be made here?
The key term when it comes to this question, and it's a good question, is a reasonable expectation of privacy. So what is your reasonable expectation of privacy in using your own phone at work? And I would say that's strong. And it's much stronger than using a phone they buy you. Right? Or let's say we're just talking about it being in a Xcel Energy truck at a strip club or whatever. What's your reasonable expectation of privacy when you have that car, right? And it's less than if it was your car. And so, my advice again is if you have your own phone, bring it to work and do your Facebooking from there. No one can work for 8 hours straight without a break, right? But I probably wouldn't be surfing the internet on a computer that my employer bought me. Now, is it good for them to block ESPN.com? I think, again, that's morale killing type stuff. So where's that balance there? When you just need a mental timeout to check your Facebook account for 5 minutes, well, do it on your own phone. And if you're in an Xcel Energy truck, I wouldn't go to a strip club. I think they have every right in the world to monitor where that truck is.
How about this one? How about if I bring my personal computer to my workplace and log on to the Wi-Fi network owned, operated, and paid for by the company? Or
your cell phone. You log onto the internet from your cell phone. So they can see. So here's the deal with that. They can see, obviously, what sites you're going to. They just can't see what you're sort of typing in your, let's say you have an Excel document open and you're on their network. They can't read that file, but they can see what websites you go to. And so, again, I would take your phone, I would get off their network, I would put it on Verizon. And then, I really would, and that's not painful, and it's a nice balance. They'll never know it, and they can't really see what you're doing in that case. And again, if they did try to monitor that, I would classify that as poor, because if you did a cost-benefit analysis, there's way more cost than benefit to that. Let's say someone's doing that for 4 hours of an 8-hour day. As an employer, you'd want to know, and that's where you could look at the network and see.
Sure. Yeah.
Yeah.
Okay. Good. So, Corey, what are the kind of restrictions or limitations on employers who have monitored employees' activities and decided they found something that they thought was egregious and just fires them?
Yeah, and this happens all the time, right? And they're allowed to. Employment at will is this legal doctrine that basically says we can fire you at any time for any legal reason. So, you can't fire someone because they're in a protected class, for instance, the color of their skin or their religion or things like that. But let's say you wanted to fire someone because they were looking at their email, personal email too often. That's fine in most states. Only a few states in the country have to have a good cause to fire someone with employment at will. Everyone else, and it's the vast majority, just basically says any legal reason, they're gone. So, again, if you're an employee and you're listening to this, you need to be really careful because you're vulnerable. Now, let's say you're a contract employee and you have an actual document that guarantees you, 5 years at that job. I guarantee you there's a clause in there that's, good morals clause, productivity clause, and they monitor you there and they could still fire you. So the employers hold the vast majority of power when it comes to this because of the way that American law is. In Europe, it's a little different.
Corey, in your paper, you make a very good case that this area of employee monitoring is developing and changing very fast, especially with recent advances in technology underlying the practices. What do you see coming up in the future that might have a significant impact on not only the monitoring techniques available, but how they're likely to be used?
That's a good question. Let's talk more likely, and then we can do sci-fi scenarios. There's this software program. There's a bunch of them out there. It's basically called, eavesdropping.com. It's not, but you can pull up this whole dashboard of every single piece of equipment that you're monitoring Dan Sweeney on. So on one, computer screen, I can see your email usage, your text usage, where your badge is, where your car is. Have you been spotted anywhere else? I can pull up your social media profile. I have everything right there in front of me, and that's scary. I've got a whole profile of you right in front of me. And if I don't like you for some reason, can I find a way to justify firing you based on something that I see on this screen that has nothing to do with why I'm really fired? Sure. So there's ethical issues there, and that's happening now. And then we were talking earlier about, chip technology and sort of being able to track people with, an implanted, chip. And that technology is already here. They do it with dogs all the time. You put a tracker in a dog. And what if your company kind of says, you have to implant this in your wrist? I can't imagine Americans would go for that. But, I don't see a company not proposing it. I can see a company proposing it.
I think I read something recently about a company that tried to make that mandatory, and their excuse was we don't want these cards to be lost somewhere and picked up, so we're just going to implant this chip into you. And
then promise to turn it off at 5? I would be a lawyer in that case against that practice. I think you could argue that's an invasion of your privacy, right? You have a reasonable expectation of privacy in your body after, even at work, right? But especially after work. So, but again, companies will try stuff like that. And what about chipping your personal car? Because you could technically be a liability outside of work hours. That's true, and they'll try it. If the technology exists, there's a company that will try it. And American law is pretty weak when it comes to this.
So, are there any things that you see on the horizon, either technically or in terms of just practices, that you think will be a positive capability that companies can use to maintain the necessary secrecy, become less and less personally invasive?
Yeah, I think we will reach as a society a maximum level of tolerance for this, right? Right now it's sort of, people are upset, but they're not mad enough. And at some point that will break and boil over, and then they'll be forced to just to lead, which is to be transparent about what you're doing. Put it in plain English. Tell your people what you're doing, and just be honest about it. And then you just sort of have this trust relationship where it works. I think there will be a point where people just won't do it anymore. They won't take it. And I hope that's what happens, to be honest, so that, because there is a way to lead without monitoring excessively your employees. It just takes more time. And there's ethics all over this issue. But I guess I want to end with sort of this point. You can't be totally anti-employer monitoring, because obviously they have really good reasons to do it. And you can't be totally against protecting your employees from being monitored because it is an invasion of their privacy, legally protected or not. So where's a balanced solution in the middle? And that's what I hope we come to.
Ethically Speaking is a podcast of the Institute for Enterprise Ethics at the Daniels College of Business. College of Business. College of Business. College of Business.